For the people on Zoom that can hear me now, I would ask that you keep your microphone muted until it's your turn or your case is called. Also, keep in mind, if you do not stop your video, we can see what you're doing. And although entertaining at times, it can be a distraction. So if you wouldn't do it in the courtroom, please don't do it on the camera. And I think that's it. So with that, Mr. Schmidt.
Thank you, Your Honor.
Pacey Welch. This is cause number CR 19-0135-173. And that is filed the state of Texas versus Pacey Welch. And that is set for trial docket status. Where are we at?
Judge, this case was just transferred to your court from the 173rd. It had been continued along because they were awaiting some DNA results. Those I just received those about 15 minutes ago.
So you're ready for trial? Just kidding.
There's a companion case. I wouldn't say a co-defendant, but that I think those results are more pertinent to. They may or may not be pertinent to our case, but nonetheless, we just received those, and I think both the state and myself are wanting to reset this for. I'm sorry, I've been dealing with him the whole time.
Okay. 30 days, 2 days, whatever the court is comfortable with.
Well, it's always my experience. DNA normally asks more questions than it ever answers, at least in my experience. Resetting it.
I mean, honestly, I think. I'm going to go into the details of what it was, but I think 60 days is going to be. It asks more questions than answers.
Always does. 60 days? Is there an offer?
Not at this time, Your Honor.
Is there going to be an offer?
There was a previous offer from Mr. Dickens, but
Okay, but that's expired and there's
It
not a
has
new one.
expired, Your Honor, and
that's okay. The max.
I anticipate making an offer in this case, but I have not been able to get in touch with the victim. So
June 10th, 1:30. All right, so Ms. Welsh, can I see the indictment?
It's not one of them.
Okay, well, I'm curious. Okay. All right, and so Ms. Welsh, you have your reset notice there, June 10th at 1:30. Stay in touch with your bondsman and your attorney. We'll see you back in June. You're free to go. Thank you, ma'am.
May I be excused, please? May I be excused?
Yes, ma'am.
Okay. You need the whole one.
Mr. Files.
Yes, Your Honor, we have Jefferson Allen, who's number one on the court docket today.
Jefferson Allen. Doing all right.
Good morning, Your Honor. Good afternoon.
All right, this is CR 19-0693-173, State of Texas versus Jefferson Allen. And that is set for trial docket status. Where are we at?
We have a motion for continuance in order to hire a representative of a lawyer. Mr. Allen has cases that are similar in Cherokee County and in Henderson County. They have some of the same overlap as far as witnesses. So our expert is going to have to do work in both counties in order to assist us. So.
In state?
state's in agreement with that, Your Honor.
June 10th.
Yeah, I mean, I don't even really need to grant the continuance. I'll just reset it.
That's what we have.
And I'll just reset it June 10th at 1:30.
I'm just used to having bringing continuances. So.
Well, all these came over and there's a new office holder. And so I'm trying to get all these cases in court. We figure out where they're at and start new if we have to, just make offers, whatever we got to do.
I visited the state earlier. My client is a tower construction superintendent for a company that is primarily in West Texas and New Mexico. And he has been making docket calls over and over and over and has not missed one or been late for one. We had discussed with the state earlier the possibility of asking the court if he might come in June rather than having to come in on a monthly basis, as long as there's no.
If y'all don't have it worked out by June, just appear via Zoom. I'd rather him be working. Can you appear via Zoom?
We could do Zoom.
Right. If he can appear via Zoom, it's okay as long as he keeps working.
So thank you, Your Honor.
Yes, sir.
One other matter of interest. I'm going to do something that the court in a different life would have enjoyed. I'm counsel for one of the January 6th cases up in DC. So we're going to be going back and forth to DC.
No, I hope you have fun with that. I think
Just when you think you've seen almost everything, there's always something new.
Yep. Good to see you.
Good to see you, Your Honor. If that's all
Mr.
the business I
Allen,
have before the
June-
court, may I be excused?
Yes, sir. Yes,
Thank
sir.
you.
June 10th, 1:30.
Thank you.
Yes, sir. Mr. Head.
Governor, Louis Corwin on page 3, he is appearing by Zoom.
I'm here, Your Honor.
And he's appearing by Zoom because,
Governor, I sent him a notice that it was going to be by Zoom initially. I failed to get him notice that it had changed to in person until I tried to contact him today and he was out of town.
alrighty, fair enough. All right, it's cause number CR 19-0737-173, the state of Texas versus Louis Corwin, and this is set for trial docket status. Where are we at?
Your Honor, this was transferred from the DA's office to our office in January, and I believe I'm correct that we need some additional discussion. There's issue over restitution, Mike and I talked about. It's going to need additional development.
I'm sorry.
Going to need additional development.
We all had it since January. It's
And Your Honor,
March, end of March.
We've met a couple of times. It's a issue about restitution and there was a lease agreement. It's kind of a convoluted sort of fact pattern that, of course, it's our position that it's civil. It's
Yeah,
the
that's going to
state's-
say if there's a lease agreement,
It's the state's position, it's not civil. And so we're trying to sort through that. But I don't think Mr. Burgett's had it long enough really to converse with the complaining witness and make a decision about restitution and various things.
how long you need? Couple days. You've had it since January. That's why I set these. We gotta do something with these cases or I'm gonna start having
No,
trials every week.
no, that's understood. But it's going to take longer than that to try to track down some of these particular.
April 29th. It's a month.
Trying to think what I'm set for something on the 29th.
Your Honor, I'll be here that day. I have some other stuff that I think is probably more likely to go to trial. That's older
Right.
and potential jail cases, but if we want to reset it for that date to see where we are on it, certainly. I have no
Sure, let's do
objection.
April 29th. And if you need a different date,
Yes.
just tell Kevin.
That's fine.
April 29th, 1:30. Mr. Corwin, April 29th at 1:30. And, if you're working out of town, I don't mind you zooming, but if not, I need you here in the courtroom.
I should be able to make it in person, Judge. Thank you very much.
All right, you're free to log off. Stay in touch with Mr. Head.
Yes, sir. Yes, sir. Thank you.
Thank you.
Yes, sir.
Your Honor, my next case is Raymond Mathis, same situation. He's appearing by Zoom as well. Rest of my clients are in person, but I failed to get him notice and he's actually working out of town today.
Mr. Mathis, you got me?
Yes, sir. I'm present. Can you hear me?
Yes, sir. I'm going to call your case then. This is cause number CR 19-0918-173, the state of Texas versus Raymond Mathis. That is set for trial docket status. Where are we at?
Your Honor, the previous administration had extended a 5-year deferred offer to Mr. Head and his client, which is still on the table.
Your Honor, I'll be glad to discuss that with Mr. Mathis again, but we had previously on the record rejected that in the other court. And I don't expect any change in our position.
Is there any change that's going to be made in the state's position? I'll reset it. It sounds like y'all might be close. All right, April 29th, 1:30. All right, Mr. Mathis, I'm resetting your case to April 29th at 1:30. And unless you're working out of town, I need you here in the courtroom. Stay in touch with Mr. Head and I'll see you one way or the other, April 29th, 1:30.
Yes, sir. I do work in Fort Worth. I do work and reside in Fort Worth, Texas.
Okay, fair enough. Just let Mr. Head know and then he'll pre-clear it.
All right, thank you.
Yes, sir.
Thank you,
You're free to
Raymond.
log off.
Your Honor, on page 4, Michael Welsh.
Michael Welsh. This is cause number CR 18-0775-3, the state of Texas versus Michael Welsh, again set for trial docket status. Where are we at?
Your Honor, this is the case that's the companion case to Tacey Welch that the court just reset, I think about 60 days out due to the DNA issue.
June 10th,
Yes, Your Honor.
June 10th, 1:30. Mr. Welsh, we'll see you back June 10th, 1:30. If you're on conditions of bond, make sure you abide by them and stay in touch with your attorney and your bonds. Yes, sir. All right.
And then, Your Honor, on page 2, Jeremy Cook is in custody.
Mr. Cook, come on up. These are cause numbers CR 21-0288 and 0289-173, and both of those are styled State of Texas versus Jeremy Cook and set for arraignment. Mr. Head.
Your Honor, Mr. Cook's name does appear correctly on the indictment. He understands the nature of the charge in each indictment, would waive the formal reading of the indictment in each case, and plea if not guilty for purposes of arraignment on each case.
All right, Mr. Cook, then the court notes plea of not guilty to each of the indictments for purposes of arraignment. Your two next court dates are June the 9th for discovery status, and then again on July the 14th for pretrial. And both of those are at 9 a.m.
Your Honor, these are re-indictments of, well, we have a special setting for October, I believe, right?
For trial?
Yes, sir. These are,
Oh, well, I
these
had-
were originally CR 19 cause numbers. We took them back to the grand jury a couple weeks ago, re-indicted, dismissed the CR 19 cause numbers. So these are new indictments. And we had previously gotten. I'll get them for you.
What about that, that second, or that, we had 2 trial weeks, but could we not put him in on this coming up?
There's still some outstanding.
I don't know if you have to be acceptable anymore. I don't need it. I mean,
I think it was gonna be a 2-week trial. This is gonna be a 2-week trial, so we're looking at the best place to put it.
we've got a trial. I'll let everybody know. So I've got a trial open somewhere, so we're gonna fit somebody in there.
We looked all the way from, we have special set from May next month, or April, and then May. We looked through June
Okay,
and October.
so we can't do it this.
October was the best one.
And what day is that?
I think it'd be a good idea, yeah. We could get
We're
a
gonna
kind
start
of
holding that
status
court.
date.
Trial will start October 18th. And we'll go.
Which ones are those? Oh, yeah, I didn't call the other two. So there's, well, those are the 2 CR19s. I see them. The CR19s are on my docket too, and y'all have got motions to dismiss on those.
That's our understanding, Your Honor, is that those,
The 748 and 749, those need to stay on the docket. Those have not been re-indicted. They're not going to be dismissed. It's the original attempted capital murder and the original unlawful possession of a
Okay.
firearm by a felon that need to be dismissed.
All right. I guess there were 2 I didn't call. CR19 0748 and 0749. Those are still staying on there?
Yes, sir.
Okay, I got you. So this is set for October
October 18th.
for jury selection?
Yes.
All right, so what I'll do then, of course, we've arraigned him then. Don't worry about those other 2 dates. This is set then for, well, if they're re-indictments, we don't need them. We'll just set this for October 18th for jury selection.
Your Honor, if we could maybe just get a kind of a status date sometime late July, early August, just in case there are any issues we need to bring to the.
How about
court's
July
attention.
14th at 9 a.m.?
Yes, sir.
Is that good, Kevin? It's already. Rather not.
I already wrote it down, Kevin.
Obviously, just quit.
July 14th, 9 a.m. And then again, October 18th, 8:30 a.m. for jury selection. You have a seat, Mr. Tripp. Thank you.
Your Honor, on page 3, Efren Garcia.
Efren Garcia. Come on up, sir. This is cause number CR 19-0908-173, the state of Texas versus Efren Garcia. And again, trial docket status.
10 for 10, is that the last offer you got?
It was, and we had previously in the other court rejected that offer, Your Honor. I think there might honestly be some room for negotiation on this case if we could get until April 29th and discuss it, we might be able to come up with a resolution.
Can I see the indictment? All right, then the court will reset this till April 29th. However, Mr. Garcia, I am going to order you to take a drug test today. We'll go with probation, take the test. When you get done, come back in the courtroom and we'll go over the results together.
Step around the corner.
Is that April 29th, 9 or 1:30?
April 29th at 1:30.
Then, Your Honor, we have pleas on Mr. Coker's case. If I could be excused, I'll
Yes, sir.
go take care of that paperwork.
Ms. Moore.
Good afternoon. I think I'll start on page 7.
Scott Dick.
Yes.
Mr. Dick, come on up. This is cause number CR 19-0807-173, the state of Texas versus Scott Dick, set for trial docket status.
Mr. Dick was arraigned the 25th of March on 2 new cases that are set for status discovery on May the 12th. We have never been able to work out this case. I'm hopeful that I haven't received a new offer or the discovery on the new cases yet, so I would like to be able to review those. We may still need a trial, but
I'm going to set this one on May 12th and just run it along with the others.
yes, Your Honor. And I've talked to Mr. Dick and he's acceptable to having this case continue.
And this is 9 is that May 12th, 9 a.m. or 1:30? 1:30. Okay. All right, then, Mr. Dick, I'm going to reset your case to run along with your other cases on May the 12th at 1:30. And how long has he been in jail?
I want to say since about December. He was out.
Okay.
He got arrested.
Until the 2
because
new
of the
cases. Okay.
Yeah.
All right, we'll see you in May. If you get out of jail between now and then, I need to see you back here May 12th. Lisa Greer. All right, this is cause number CR 19-0741-173, the state of Texas versus Lisa Greer, and set for trial docket status.
Your Honor, there has been an offer on the table for a long time with the last administration. Ms. Greer wanted a jury trial, and we've been waiting for that.
Got one coming up.
16th.
Your Honor, I'm taking my second vaccine on the 15th at 4 o'clock. And if I'm well, then I'll be more than happy to be here on the 16th picking a jury.
We'll keep that in mind. We'll see how the rest of it shakes out, but I could give her a trial then. But either way, what I'm going to do is I'm going to reset it for April 29th at 1:30, and we'll keep that one, see how the rest of the docket shakes out, and we may be able to make that work. Depending on if I've got somebody in jail that we can make it work, I need to do that first. But Ms. Greer, before you go, based upon the nature of your charge, I'm going to order you to take a drug test today. You'll go take the test. When you get done, come back in the courtroom and we'll all go with the results together.
And just have a seat, either inside or outside. Where do you want her to?
Let's go with probation. Stephen Jackson.
Yes.
Mr. Jackson, Stephen Jackson. Taking my second shot.
Oh, you're not?
Because I've already had it. And then I got first.
I'm nervous about it, but
This is CR 19-0874-173, the state of Texas versus Stephen Jackson, set for trial docket status.
Your Honor, Mr. Jackson is present and ready for trial on this particular case. He was indicted recently on a new charge, and that case is pending status discovery on May the 12th in your court.
Let's do that. Let's take this case, set it on May the 12th so it can run with those others.
That'd be good.
So May the 12th at 1:30. And is there an offer to wrap all this up?
I haven't received the discovery or offer yet on the case, Your
Okay.
Honor.
Did he wish you would? Seen that yet, but
Oh, well.
I'll get it to you.
Richard.
Okay,
Okay, I haven't-
Ms. Moore and I will talk between now and May 12th.
All right, May 12th. See you back then, Mr. Jackson, 1:30.
Mr. Jackson, do you see?
Yes, ma'am. You're free to go, sir. Yeah, let's see, Mr. Stevens. Yes, sir.
Call them whichever order the court would like.
I'm sorry.
Whichever order you want to call them.
We'll start at the top. Kenneth
right.
Bone, Mr. Bone, come on up. All right, this is cause number CR 20-0017-173, the state of Texas versus Kenneth Bone, and set for trial docket status.
Judge, we have states made an offer. They actually reduced the offer a couple of months ago.
What's the offer right now?
Five TDC.
5 to do?
Yes, sir. And I had a conversation with Mr. Bone at that time, which he rejected the offer.
Okay. Another one of those we could put on the list for April 16th.
he's got another case, the CR 20 case. It's set for discovery status on April 15th.
All right. Let's just run them both together. And so that's why we have these dockets, figure this stuff out. So let's, Mr. Bone, I'm going to set your case for April 14th. Did you say 1:30? At 9 a.m., April 14th, 9 a.m. with your other cases. However, before you go, based upon the nature of your charge, you're going to go take a drug test today. And when you get done, sir, just come back in the courtroom and we'll go over the results together. But don't leave. Come right back in here when you're done.
Come back.
Given. Janet Given. Or Jeanette, sorry. This is cause number CR 19-0621-173, the state of Texas versus Jeanette Given. And this is set for trial docket status.
Yes, sir. We do have an offer, Your Honor. The offer was to reduce it to a misdemeanor and give her 2 years deferred adjudication, and she has rejected that offer.
Is this a second degree felony? Or third?
Second degree felony, yes,
All
sir.
right, so if she were to be, we do have an April 16th trial coming up. who she represents. Give me just a moment. I may be conflicted. Does she have a CPS case pending? Is she involved in a CPS case right now? All right, and my wife's your lawyer? Well, I can't be the judge over your case, because if I do something that she don't like, I'm in trouble.
I don't know, sir. I'm not trying to cause no trouble with nobody. I
Me
do not-
either. So I'm
It's-
gonna,
it's not your fault.
I'm gonna recuse myself, because I don't want to get in trouble, you know what I mean? And so what I'm gonna do is, actually, I could be fair and impartial, but it doesn't look good, and I'm not gonna do it. So I'm gonna recuse myself, and then we'll get an order. It'll have to go up to the administrative judge, and I don't know whether Judge Calhoun will be appointed or someone else. It's up to the administrative judge. And so what I'll do, though, is I'll go ahead and, well, I don't want to set anything on his docket, so Kevin will take care of it. So, Ms. Given, we will just see you when we see you, so another court will have to deal with it. Stay in touch with your bondsman and your lawyer.
We don't have that. That's all. Yes, ma'am.
Tedrick Rockmore.
Yes, sir.
Tedrick Rockmore.
He's out in the hallway.
He's right there. All right, this is cause number CR 19-0140-173, the state of Texas versus Tedrick Rockmore, set for trial docket status. Yes, ma'am, where are we at?
I've made an offer 7 years.
7 years?
7 TDC, Your Honor. My
Okay.
client and I have discussed the offer, and at this time, he has rejected the offer. Am I correct on that?
Okay, are y'all familiar with this?
I am, Your Honor.
Okay, are we hearing that today? Bond supervision? Basically violation of bond report?
I wasn't prepared, no.
You might never know about it.
Give me just a minute. Mr. Rockmore, while we figure this out, go ahead and have a seat in the jury box, and I'll call this here in just a little while until we figure out. All right, so I'm going to recall that one.
All right, Judge.
Do y'all have a copy?
That was, it was in the file. It's been filed with Odyssey.
All right, next is Mr. Nope, yes, sir.
Keith Mayo here for William Kennedy, Your Honor.
I'm sorry.
William Kennedy.
Hit. Do you know what page it's on?
No, sir, I haven't seen the docket. I just know we got.
Well, we
signed here from one.
page 6. William Kennedy. This is cause number CR 18-0513-173, the state of Texas versus William Kennedy, and set for trial docket status.
Your Honor, there's no offer at this time. I've been unable to reach Mr. Mayo, so I'll get with him after this and get his contact information so that I can send an offer over.
Yeah, we had an offer from Mr. Dickerson, but I know, I think he's gone now, but we did have an offer which was 10 years, maybe 10 years deferred or something. Which that had changed a couple of times before we got that, so.
Yeah, that's really one of the reasons I wanted to bring y'all in on these, see if we can kind of reset where are we at.
Right.
Let's get them back in a
And we're
some
changing
conversation.
course too. This is our first appearance over here.
Okay. April 29th, 1:30.
That sounds good, Your
All
Honor.
right, April 29th, 1:30. Mr. Kennedy, if you have conditions of bond, make sure you abide by them. Stay in touch with your lawyer and your bondsman. And I
Yes,
will
sir.
see you April 29th at 1:30.
All right. Okay.
Yes, sir. Mr. Skelton.
Dina Thomas, she's the last person on the list.
Last person, page
Next to
8.
last.
You got another one too.
I do, he's here too.
Okay.
I want to go ahead and announce Mrs. Thomas.
I got you.
She
Dina
is-
Thomas.
She's out in the hall, yonder. She's in a wheelchair. She's having trouble today, so shall I have to bring her all the way up here or?
Well, at least bring her there to the well. I mean, to the gate, the non-existent gate. All right, that's good right there. Ms. Thomas, you hear me okay? And I'm gonna call your case. It's cause number CR 19-0378-173, the state of Texas versus Dina Thomas, set for trial docket status. Where are we at?
Judge, I think we, excuse me, I'm going through my email. Mr. Skelton and I have recently communicated about this case, and I think we have it worked out, don't we?
Well, honestly, I'm not sure we do.
Well, we're here today. Do I need it? Why don't I recall it and y'all see if y'all have it worked out?
Sure, we can talk.
Y'all talk. All right, then next is, and I will have Ms. Thomas take a drug test when it's over. If for some reason y'all can't work it out, just so y'all know that. Next is Terrence Gurley.
He's here. No, we have a plea worked out in that case.
Y'all got paperwork done?
We do not have the paperwork done.
All right, there's a plea worked out.
We have a plea worked out, but I need to go over the paperwork with him.
Okay, well, y'all go ahead and do that and I'll recall it.
Do you have the paperwork?
Yeah, we have-
Okay. I'll just name on.
Mr. Mills. Matthew McEwen. This is cause number CR 19-0806-173, the state of Texas versus Matthew McEwen, and that is set for trial docket status, but I have a note that this is set for trial in August.
I think we were going to special set it, I think was the plan for August,
Okay.
Which is fine with us.
That's correct. I just haven't worked out the announcement that I'm working
Because
on.
we got to work with the text and everything else.
Yeah. I'm working on the special settings. So
Okay, so that's what we're going to do. Mr. McEwen, basically, we're setting your case for trial in August, but we have to do our jury selection at another place over at the Old Texan Theater. And so it takes some time to coordinate that, but it should be in August. So is there any offer or is this going to be a trial?
Judge, we're still talking. The previous administration made an offer and Mr. McEwen turned that down. And Mr. Cox and I are still talking. And so.
How about we do this? I'll reset it to April 29th at 1:30. And that'll give you all about a month to see if you can work it out. If not, then I'll set it for one more setting for status and then I'll set it in August.
Okay.
For trial.
That'll be fine. Go ahead. Have a Brian Burns.
Brian Burns. Top 5. Well, we got April 16th.
Yeah, Mr. McEwen. Are you talking about Mr. McEwen?
No, Mr. Burns.
Oh, I think Mr. McEwen's been in jail right almost 2 years.
Yeah.
Yeah.
I got it. Hey, I got an opening April 16th. We're gonna put somebody in it.
I think, oh, I'm sorry. Look,
All right, cause number CR 19-0677-173, the state of Texas versus Brian Burns, and set for trial docket status.
Your Honor,
Go ahead.
Mr. Mills and I have been talking. We would like to ask for a special setting in September in this case.
In April,
September.
April 16th.
That's fine with us, Judge.
Here's the problem with special settings, is that if you set a special setting and then something happens, then we burn a jury and we burn a week.
He's been in jail so long, I can't imagine anybody except Mr. McEwen being in jail longer than Mr. Burns.
And we're gonna say him in August.
Right, so whatever the court wants to do.
Well, I don't mind specially set it, but what I'll do is I'll special set him number one, but there'll be cases behind him, so we don't burn a jury up.
Yes, sir.
I would say a
3 or
week
4 or 5 days.
more.
So a work week.
Yes, sir.
Okay. Do we have a date?
We have 2 different dates.
Oh, you have those.
September 13th through the 17th, or September 27th through October. The second date would work better for me. I'm supposed to go somewhere.
You
the
will be
16th.
coming off of judicial conference from the.
Sounds like a plan. Which judicial conference?
The annual. I don't know what they're gonna do.
I think it's virtual anyway.
I don't think they made it.
You're in person? We're in person? Where is it at?
Yours is.
Yeah. That's what I want to see. All right. So September 27th, jury selection, 8:30 a.m.
I'll work out the announcement date.
And we'll set that for an announcement date a couple weeks before then. But we are setting you for trial, Mr. Burns, September 27th, picking a jury at 8:30 a.m. Maybe here, I don't know yet.
Thank you, Your Honor.
Yes, ma'am.
Crystal Thompson.
Crystal Thompson. Gotcha. All right, this is cause number CR 19-0513-173, the state of Texas versus Crystal Thompson. Is there a Crystal Thompson in the courtroom? I hear no answer. Is there a Crystal Thompson appearing via Zoom? I see nor hear anyone. She is not in the lobby. She received proper notice. The time is now 2:07. Docket was set at 1:30. The court will entertain a motion.
Statement moves for bond forfeiture.
Granted, capious issue shall be held with no bond. And if you can, I'm here all day if you
Yes,
find
sir, I
it.
understand. Maybe we can take care of that. I think that's all I have on the docket.
Yes, sir.
Thank you.
Yes, sir. Proceed. Head.
Standing in for Mr. Weiner on Audrey Hart.
Audrey Hart. This is cause number CR 19-0372-173, the state of Texas versus Audrey Hart. And this is set for trial docket status. Where are we at?
Your Honor, I've been speaking with Mr. Weiner, and I believe we're going to have this case resolved, I would say within 30 days, if we could just get a new setting.
April 29th at 1:30.
Sure.
All right, I'm going to reset your case then to April 29th at 1:30. So we'll see you back at 1:30 on April 29th unless it's resolved sooner.
Just contact me. Your Honor, on page 4, D'Angelo Russell.
D'Angelo Russell. This is cause number CR 18-0722-173, the state of Texas versus D'Angelo Russell, set for trial docket status.
Your Honor, there was a offer made quite some time ago for payment of $750 in restitution, and if the case would be dismissed. Mr. Russell has advised me that he does have that money together, and he's going to drop it by the office later today. So I think if we can pass it to the 29th.
I'll be here all day. Or can we
should
make
be
it
able to
happen next
hopefully
week?
get
I'm
that-
sure he wants it dismissed, so you have to come back. But here's what I'll do. I'll reset this for April 29th at 1:30. If he gets that handled sooner and I'm presented with a motion to dismiss, he doesn't have to come back.
Yes, sir.
Take a look at the last case and,
In fact, we'll need to amend the indictment.
somehow.
Your Honor, the name is incorrect on the indictment. The name on the indictment is Ramon Russell Danglo, but that's just a misspelling, I believe. Mr. Russell or Mr. D'Angelo's name is actually Russell Ramon D'Angelo.
Is he the one that's also set for Raymond there on that evading arrest case?
I'm assuming he is, Your Honor. He did have an arrest for evading. And so the name's quite a bit off, but I would assume we're assuming that's him. We just need to correct that.
They're tied together in
They're
Odyssey.
tied, but there's also a 2017 CO2 case that has the same spelling of reckless driving.
What are you? So is he appearing for arraignment on that?
He is, Your Honor.
Okay. All right, so here's what I'll do. I'm resetting that one again to April 29th at 1:30 unless I'm presented with a motion to dismiss before then. And then we'll move on to CR 21-0178-173, the state of Texas versus Raymond. I've got Danglo on here, set for arraignment, Mr. Head.
Your Honor, Mr. D'Angelo understands what he's charged with in an indictment, would waive the formal reading, enter a plea of not guilty. However, his true and correct name is actually Russell Ramon D'Angelo, D'Angelo.
So Russell, 2 S's, 2 L's, and
Yes.
then Ramon, Ramone.
Rahmon.
I'm sorry, say it again.
Rahmon, Ramon.
And then D'Angelo, Deangelo.
Yes, sir.
All right. Can I see the indictment, please? Is there any objection to me interleading and correct the indictment of his incorrect name and placing in the correct name?
No, sir, Your Honor. No objection.
All right, just for the record, I'm going to change it in the heading and in the body of the indictment.
Your Honor, Mr. D'Angelo has some health issues. He was asking if he could just go ahead and have a seat. He was having an issue with his legs. He was a victim in a gunshot wound not too long ago.
Here in this county?
Yes, sir.
Okay, well, I think I'm done with the, right?
Go ahead and have a seat.
Go ahead and have a seat. I don't want you to fall. All right, so then court notes is plea of not guilty for purposes of arraignment has, I didn't sign the indictment. I guess I need that back. I didn't sign initially, but I did it. The court has corrected the name in the indictment without objection. And Mr. D'Angelo, if you can still hear me, your next 2 court dates are June the 9th on this case at 9 a.m. for discovery status. And then again on July the 14th at 9 a.m. for pretrial. And so as soon as you receive those reset notices, sir, you are free to go.
Your Honor, I think we're ready on our pleas on Mr. Coker at this stage. Sign the paperwork.
Let me guess, we're going to plead to all four. They're just two. How many is he pleading to?
Your Honor, pleading to 2 cases and then 2 are being taken into consideration.
Okay.
One of the ones that he's pleading to, he's actually set for arraignment on today, so he's not formally been arraigned on that.
All right, I'll do that real quick. A little
Yes, sir.
raining, if I can figure out what I did with my docket. Here it is. Let's. These are rain. I'll just call them both for arraignment. We'll arraign them and then we'll move on. You ready?
Yes, sir, I think so.
All right, this is cause number, or these are cause numbers. CR 21-0194 and 0195-173. The state of Texas versus Larry Coker set for arraignment. Mr. Head.
Your Honor, Mr. Coker's name does appear correctly on those indictments. We understand the nature of the charge. He would waive the formal reading for purposes of arraignment and for purposes of arraignment enter a plea of not guilty on each case.
All right, then, Mr. Coker, the court notes your pleas of not guilty for purposes of arraignment. And now I'll call the next 2 cases. CR 19-0195, 0196, and then again on 0194. Dash 173, the state of Texas versus Larry Coker. And these are set for a plea, or actually set for trial docket status. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Coker.
We're ready, Your Honor.
All right, and just for the record, these are pleas on CR 21-0194 and 0196-173.
Just for clarification, is CR 19-0196?
I see it. Yes, CR 19-0196. Thank you. And so, sir, is your name Larry Ray Coker Jr.?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury in this bail jumping case? And also in CR 19-0196, this 3rd degree felony assault. And both of those are 3rd degrees. Is that you?
Yes, sir.
You can raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
You can lower your hand. Mr. Coker, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into these plea bargains with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Coker, have you ever been treated for any mental health or emotional issues?
Yes, sir.
And what would those be?
Just anxiety.
Right, are you on medication for that?
Yeah, I'm a drug dealer.
I'm sorry?
Yes, sir. Yes, sir.
All right, and is the jail giving you that medication as they're supposed to?
Yes, sir.
And are you taking it?
Yes, sir.
All right. And Mr. Head, do you believe your client is competent?
I do, Your Honor.
And Mr. Coker, I didn't ask you, do you understand what's going on in here?
Oh, absolutely. Yes, sir.
Well, Mr. Coker, even though you've told me you've been diagnosed with that based upon your demeanor, your answers to my questions, and the statements from your attorney, the law presumes you competent, and I have no reason to find otherwise, so I'm going to find you are competent. Mr. Coker, I know that you've already been arraigned on each of these cases, on one of them just a few minutes ago. However, would you like the prosecutor to read the indictments against you out loud here in our courtroom? But do you understand the charges?
Yes, sir. I do.
Well, as indicted, both of those charges are 3rd degree felonies. A 3rd degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand the range of punishment in each case?
Yes, sir.
And the plea bargains?
Yes, Your Honor. The agreed plea recommendation in CR 19-0196-173 on the assault family house impeding breath, third-degree felony. The state's recommendation is 3 years in the Texas Department of Criminal Justice Division to take in consideration CR 19-0195-173 with time credit of 607 days as of today, $1,050 in attorney's fees, and $249 in court costs. And that is to run concurrent with CR 21-0194-173. In addition to this, there's an agreement for a lifetime protective order that's filed on CV 21-0132-CC1.
And is a complaining witness on board with the plea bargain?
Yes, Your Honor.
Okay. Anything else? Sorry.
And then CR 21-0194-173, the agreed plea recommendation on the third-degree felony of bail jumping is 3 years Texas Department of Criminal Justice Institutional Division with time credit of 607 days as of today to run concurrent with CR 19-0196-173 and to take in consideration CR 21-0195-173.
Right. And Mr. Coker, did you get all that?
Yes.
Is that your understanding of the plea bargains?
Yes, sir.
Mr. Head, is that your understanding?
It is, Your Honor.
Mr. Coker, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple of these documents with you. The first is the agreed plea recommendations. Now, there's one for each case. Did you read and go over each of those with Mr. Head?
Yes, sir, I did. Your Honor.
Both the front and the back?
Front and back.
And did you sign the front and the back?
Yes, sir, I did.
Do you have any questions about it?
No, sir, I don't.
The next document I'm going to refer you to then is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read over this document? There should have been one for each case. Did you read over that?
Yes,
They
sir.
say the same thing. It's just the cause numbers at the top.
Yes, sir.
And did you sign it?
Yes, sir, I did.
Do you have any questions about it?
No question about it.
Do you have any questions about any of the documents you went over with Mr. Head related
No,
to
I
this
don't,
case?
Your Honor.
Well, if you read and went over these with Mr. Head, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir, I don't.
Do you want to enter into this plea bargain in each case?
Yes, sir, I do.
Then I'll ask you, sir, in cause number CR 21-0194-173 to that third-degree felony offense of bail jumping, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
I'm pleading guilty because I'm guilty and not for any other reason.
I hear the evidence.
Your Honor, state author states Exhibit 1, discovery.
Put it that way. We've changed it
No
up a little bit on
objection, Your
you.
Honor.
Admitted.
That's all, Your Honor. State rest and closes.
Rest and close, Your Honor.
I guess I didn't take it in the other one. I should have taken them both. All right. And then in cause number CR 19-0196-173 to that third-degree felony offense of assault, are you guilty or not guilty?
Guilty, Your Honor.
And are you pleading guilty because you are guilty and for no other reason?
I'm pleading guilty because I am guilty and for no other reason.
I'll hear the evidence in that case.
State author states Exhibit 1, the offense report, and states Exhibit 2, the discovery inventory report.
No objection, Your Honor.
Admitted.
State rest and closes, Your Honor.
Mr. Head, on any of the cases?
Rest and close.
All right, then Mr. Coker in CR 21-0194-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense as charged in the indictment. The court will follow the plea bargain and considers the indicted case annotated on the agreement, on the plea agreement, and sentences you to 3 years confinement in the Texas Department of Criminal Justice. You do have time credit of 607 days as of today. Court orders you to pay your court costs. And this will run concurrent with CR 19-096-173. And in that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense as alleged in the indictment. The court follows the plea bargain, considers the indicted case annotated on the plea recommendation and sentencing you, sentences you to 3 years confinement in the Texas Department of Criminal Justice with credit of 607 days and orders you to pay your attorney's fees and court costs. And special terms are the agreement with the lifetime protective order on the complaining witness named in the indictment. And this will run concurrent with CR 21-0194-173. And the court finds on the record that the complaining witness is okay with the plea agreement. Mr. Coker, before you go, just a few things I need to cover with you. First, did you have an opportunity to review the judgment in each of these cases with Mr. Head? In each of those judgments, was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. And next, now that you've been found guilty of these felony offenses, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, refer to the document in your plea packet or consult with an attorney. And with that, Mr. Coker, you're now remanded back to the custody of the Henderson County Sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, sir. You need to see Mr. Halbert to your right. Yes, sir.
Your Honor, I believe the last thing I had was Mr. Garcia was.
Yes.
the Results of his.
Mr. Garcia, come on up. All right, this is cause number CR 13. CR 13, that's wrong. That's the right one. CR 19-0908-173. Whoops, all kinds of wrong. State of Texas versus Efren Garcia. Mr. Garcia was ordered to take a drug test today. He's taken the test. It appears as though he's tested positive for cocaine and admitted apparently to snorting it on March 26th. Mr. Garcia, is this your first trip to my courtroom?
It is, Your Honor. I don't recall him having bond conditions other than standard DWI type bond conditions out of the 173rd.
You see anything, Kevin?
Sir, he's non-reporting bond conditions based on can't drive a vehicle without an interlock device.
And that's it.
That's it.
All right, I'm going to add bond conditions for you, Mr. Garcia. It's your first trip to my court. I'm not going to find your bond insufficient today. No alcohol, no drugs that are not prescribed, no illegal drugs, that includes cocaine, and no marijuana, no matter which state or state of mind you happen to be in. And so here's the deal. You're back in April. In April, you can probably guess I may drug test you. And if I do, and you test positive, you may go out that door and not that one. Yes, I understand. All righty. If you need help, ask. Lots of help out there. See you in April.
We're gonna need your signature on this to say you understand what the judge just told you about the bond conditions, no drugs.
And as soon as you receive that bond conditions, you're free to go. Oh, I was supposed to say, we've seen Mr. Herring, it's right there.
Signature here. Then your address here. Yes, just on that top line. Address here.
Ms. Greer, you're free to go, ma'am. You passed your test.
All right, that's all I have, member excused.
Yes, sir. Let me handle Mr. Stevens first. He's been waiting. Mr. Stevens.
On page 9, Rosemary Bordeaux.
Rosemary Bordeaux? How do I say it? Bordeaux? Bordeaux, okay. Thanks. All right, this is cause number CR 18-0649-173, the state of Texas versus Rosemary Bordeaux, and this is set today for a competency hearing.
And Your Honor, kind of to give the court some background, this was a case out of the 173rd. She was found incompetent to stand trial back in 2018, 2019. Since that time, she's been in Vernon with competency restoration. She is now competent and regained her competency. Obviously, she has a whole lot of back time since she's been there. I've had conversations with her today. I feel confident she understands the circumstances. I have not seen that document. We did receive a call that she was restored competency, and I do trust that she is.
All right, so here's what I'm gonna do. I'm gonna have the competency hearing first, and then depending on that, then we'll move on to the next hearing.
Yes, sir.
That way we can bookmark the hearings. And so it's set for a competency hearing. The court has received or at least it appears as though Judge Moore had found the defendant incompetent. She was sent to Terrell for competency restoration. This case was subsequently transferred to this court. This court has received a copy of the letter addressed to Judge Moore addressing Mrs. Bordeaux's or Miss Bordeaux's competency. And it basically states she'd been seen on a regular basis, and an ongoing evaluation of competency had taken place. And according to Dr. Mills, which was reviewed by Dr. Messer, that it is in Dr. Mills' opinion that Ms. Bordeaux is now competent to stand trial. And this letter was dated March the 15th. So a little more than a couple of weeks ago, 2 weeks ago, actually. And so does anyone wish to review this, or does anyone challenge the doctor's finding of competency?
Not the state, Your Honor.
No, Your Honor.
Okay. Well then, Ms. Bordeaux, do you understand what's going on today?
Yes.
And do you believe you understand what these proceedings are all about?
Yes.
All right, let me place her under oath real quick. I'm not going to ask her about her case. So you mind?
No, sir.
All right, ma'am, you can raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. And ma'am, so they taught you some things there in Terrell State Hospital?
I think she was actually in Vernon.
In Vernon, I'm sorry. Were you in Vernon?
I was in Vernon and Terrell.
In Terrell? Okay, did they adjust any medications or anything?
I was on medicine.
Are you still on it?
Yes, sir.
And are you taking it as you're supposed to?
Yes, sir.
Okay, who's that gentleman you got with you there to your right?
Stephen,
Okay, and you know what his job is?
defend me.
Okay, and how about this gentleman to the left? I don't know if you've met him before, but do you know who that is?
No.
All right, well, he represents the state of Texas, the prosecutor. Do you know what his job is?
Yeah.
And what is that?
I don't know how to put it.
Does he work for you or against you?
Works again.
Against you. And then we've never met, but do you know what my role here is?
Yours is, yours is make the final decision.
Kind of, sort of, yeah. And if you were to have a jury trial, do you know what a jury does?
They're for you.
They do what?
They said they're for you. They find you guilty or not guilty.
Okay, sounds like she's kind of good basic understanding. You feel like you have an understanding of these proceedings?
Yeah.
Okay. Anyone wish to examine the defendant?
No, Your Honor, and I can just state for the record, when I first represented her, it was hard to even hold a conversation. Once she learned of her competency restoration, she called my office. We were able to have a lengthy conversation. Again, we've been able to have a lengthy conversation today. She's got a plan on what's going to happen as soon as we're done with this plea agreement. She understands everything. So I think she's made significant improvement since when I first started representing her. And I do believe she understands everything that's going on. She just may not understand the fancy legal terms, but she understands.
Understood. All right, well, then I'm going to find Ms. Bordoy. First of all, the law presumes you're competent. You've previously been found incompetent. However, you were sent to inpatient competency restoration. Based upon your answers to my questions, your demeanor, your attorney statements, and the doctor's report, the court is going to find you competent. And so these proceedings are adjourned. Now, cause number CR 18-0649-173, the state of Texas versus Rosemary Bordoy. A plea has been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Ms. Bordoy?
We're ready.
All right, ma'am, is your name Rosemary Janine Bordoy?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the first-degree felony offense of injury to a child or disabled?
Yes, sir.
I can get you to raise your right hand the best you can, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
You can lower your hand. Ms. Bordoy, can you read and write the English language?
You know what?
Can you read and write the English language?
Yes, sir.
All right. Are you a U.S. citizen? If it turns out you're not a U.S. citizen and you enter into this plea bargain, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Ms. Bordoy, we just went over competency in another hearing. Do you understand what's going on in here?
Yes, sir.
And again, Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
The court finds and had previously found, having previously found she is competent, I find no other reason or any other reason to find her incompetent. So the court finds her competent. Ms. Bordoy, I know that we already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud in the courtroom?
No.
But do you understand the charge?
Yes, sir.
Well, as originally indicted, this charge is a first-degree felony. A first-degree felony carries a punishment range of not less than 5 years nor more than 99 years or life in the Texas Department of Criminal Justice and a fine not to exceed $10,000. However, it's my understanding that you have an agreement with the state whereby they would recommend that you be convicted and punished as a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. You understand both those ranges of punishment
Yes, sir.
in the plea bargain?
Your Honor, it's 2 years confinement in TDC with credit for 965 days served. He's responsible for attorney's fees and court costs. Oh, we're also asking the court to consider the second count in this indictment.
Okay. Count 2.
Yes, sir.
All right. And is that your understanding of the plea agreement, Ms. Bordoy?
Yes, sir.
And is that your understanding, Mr. Stevens?
It is, Your Honor.
Well, Ms. Bordoy, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over that document with Mr. Stevens?
Yes, sir.
Both the front and the back?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
You have any questions about it?
No.
The next document is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign it?
Yes, sir.
Do you have any questions about it?
No.
Do you have any questions about any of the documents you read and went over with Mr. Stevens?
No, Your Honor.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No.
You want to waive your right to a jury trial and enter into this plea bargain?
Yes.
But I'll ask you, man, how do you plead in count 1 of that indictment to the lesser included offense of that which is charged, that third-degree felony injury to a child? Guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason? I'll hear the evidence.
Judge, I have states 1 in offense report and states 2 is my Morton compliance.
No objection.
Admitted.
State rests.
Rest and close.
All right, Ms. Bordoy, then based upon your guilty plea and the evidence, and the court has enough evidence to find you guilty and does find you guilty of the lesser included offense of that which is charged in count 1, the 3rd-degree felony. The court will follow the plea bargain, sentences you to 2 years confinement in the Texas Department of Criminal Justice with credit for 965 days. The court has considered count 2 of that indictment in punishing you and orders you to pay your attorney's fees and court costs. A couple more things we need to go over, Ms. Bordoy. This document, I'm showing you the judgment. Did you get a chance to go over that with Mr. Stevens?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, now, Ms. Bordoy, now that you have been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. Those are actually legal terms. If you have any questions about any of that, you can refer to the document in your plea packet or consult with an attorney. And if I signed a release from confinement?
Yeah, Your Honor.
All right, ma'am. You need to see Mr. Halbert to your right. Good luck to you and keep taking your medication as prescribed, okay?
Yes, sir.
Thank you.
Your Honor, that will complete my business. May I be excused?
Appreciate you. Yes,
Thank
sir.
you.
Is that lunch? Okay. Mr. Skelton, if you don't mind, Ms. Thompson, come on up.
Which case is Judge? I'm sorry.
This is cause number CR 19-0513-173, the state of Texas versus Crystal Thompson. Mr. Mills, you got us?
I do, Judge.
Okay, she's now in the
Yeah.
courtroom. I figured that's why you were here. What I'm going to do, Ms. Thompson, is I am resetting your case till April the 29th at 1:30. Okay, I need to see you here on that day, 1:30 in the courtroom.
Okay.
You're going to receive a reset notice. Once you receive that, you're free to go. And let's see, I'm recalling the bond forfeiture. See you April 29th. As soon as you get it, you can go.
Okay.
Thank you, Judge.
All right, thank you. Mr. Skelton. We have paperwork. Give me just a moment. I'm supposed to be signing that.
He's client, the next client, Mr. Skelton.
Right. All right, this is cause number CR 20-003-173, the state of Texas versus Terrence Andre Gurley, set for trial docket status today. However, a plea has been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Mr. Gurley,
We're ready, Your Honor.
right, sir, is your name Terrence Andre Gurley?
Yes, Your Honor.
And are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of possession of a controlled substance?
Yes, sir.
If I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Gurley, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain immigration consequences. Do you understand that?
I do, sir.
And Mr. Gurley, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, sir.
And Mr. Skelton, do you believe your client is competent?
Yes, Your Honor, he is.
And the court's going to find that he is competent. Mr. Gurley, I know you were already arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom? But do you understand the charge? Well, as originally indicted, this charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment? However, it's my understanding you have an agreement with the state whereby they would reduce this to a state jail felony. A state jail felony carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand that range of punishment? And further, it's my understanding that the state is recommending that the court punish and convict this as a Class A misdemeanor. A Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine not to exceed $4,000. You understand all those ranges of punishment?
I understand, sir.
In the plea bargain.
Your Honor, 29 days, I'm sorry, 26 days confinement in Henderson County Jail. Credit for 26 days. Mr. Gurley is responsible for court costs and lab restitution. We're also asking the court to take into consideration 2019-0304 CCL2 and 2019-0305 CCL2.
Is that your understanding of the plea bargain, Mr. Gurley?
Yes, sir.
Is that your understanding, Mr. Skelton?
Yes, sir.
Well, Mr. Gurley, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both front and back and sign them with Mr. Skelton?
Yes, sir.
Do you have any questions about it? The next document I want to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document and sign the second page?
Yes, Your Honor.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you read and went over with Mr. Skelton?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
You want to waive your right to a jury trial and enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment, the state jail felony, possession of a controlled substance, punished and convicted under 1244B of our penal code? Guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, I have states 1, an offense report, states 2, Michael Morton compliance, and states 3 is a lab report.
No objection, Your Honor.
Admitted.
State rest and closes.
Since closed, we don't have anything to offer in this case.
All right, then, Mr. Gurley, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense of that which is charged in the indictment. And the court follows the plea bargain and finds you guilty of the Class A misdemeanor under 1244B of our penal code. And the court is considering the 2 indicted cases or filed cases, which are annotated on the plea agreement. The court sentences you to 26 days in the Henderson County Jail with credit for 26 days, orders you to pay your attorney's fees, court costs, and lab fee. And let's see, Mr. Gurley, before you go, have you had an opportunity to go over this judgment with Mr. Skelton?
Yes,
It's your name, the charge, and the time credit correct?
Yes, sir.
All right, sir, you're now remanded. Well, no, you're not. Your time served. You just need to see Mr. Halbert to your right. Good luck to you.
Thank you, sir.
Mrs. Thomas, waiting to be tested.
I thought you had a plea worked out.
Say what?
I thought you had, I just signed.
Oh,
it.
okay.
I thought you had a plea worked out.
No, we need to talk, Judge.
We need to talk about
Okay.
it. She's in such a state right now that I don't know that I
I understand.
follow me. I mean, yes, sir.
All right, and so, Mr. Hunt,
This is Colin on page 5, I believe you are.
Have three bond hearings today, Your Honor.
3 bond hearings.
Yes, sir.
Trial docket status thing. All right, this is CB 21-0104-173 ex parte Elizabeth and Colin, set today for a writ seeking bond reduction. Is the applicant ready?
We're ready, Your Honor.
And on behalf of the state,
State's ready, Your Honor.
and are we going to hear testimony from your client for the limited purposes of bail?
We will, Your Honor.
All right, ma'am, if you could raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You can lower your hand.
Your full name is Elizabeth Ann Collin, is that correct?
Yes.
Okay. And you are currently incarcerated in the Henderson County Jail on a charge of possession of controlled substance, penalty group 1, less than 1 gram. Is that correct?
Correct.
And is it your understanding that that is what's called a state jail felony?
Yes.
Okay. And your bond is currently set at $8,500. Is that correct?
Yes, sir.
Okay. Now, you understand that a bondsman typically asks about 10% of whatever the bond is to bond somebody out. Is that your understanding?
Yes.
Okay. And do you have any money or other valuable things that you could use to post bond with a bondsman?
No, sir.
Okay. Do you have any bank accounts, savings accounts, stockbroker accounts, gold
sir.
bars buried in the backyard,
No.
jars of money under your bed, anything like that?
No, sir.
Do you have any maybe expensive furniture or like big screen TVs or computers or anything
No,
like
sir.
that? What about investments like fancy paintings or fancy cars?
No.
Okay. Do you own any land or houses or anything like that?
No.
Okay. Do you own an automobile?
No, sir.
Okay. And now you did have an automobile when this occurred, is that correct?
It was my father's automobile.
That was your father's automobile. Okay, that was not yours.
Correct.
Okay. So do you have any of your own resources you could use to post a bond?
No, sir.
Okay. Do you have any family members or friends that would loan you some money to make a bond?
No, sir.
Okay. If you were to be granted either a PR bond or a lower bond and were able to make it and get out of jail, where would you live?
At my parents' house.
And where is that?
In Maybank, Texas.
Okay. And your parents are not willing to help you bond out. Is that what you're saying?
Correct.
Okay. Have you talked to them about that?
Yes.
Okay.
No luck with that.
Okay. You understand that you would have to come back to court if you were able to bond out, either PR bond or a lower bond was given to you, that you would have to come back to court, assuming your case was indicted.
Correct.
Okay.
Yes, sir.
Would you come back to court?
Yes.
Okay. And now, just to be upfront with the court, you do have a little bit of a criminal history. Is that accurate?
Yes.
Okay. And in 2017, you had, it was in Kaufman County, you had a case. Is that correct?
Yes, sir.
And what was that case?
Manufacturing and delivery of controlled substance less than a gram in the school zone.
Okay. And so that was a felony charge originally. Is that correct?
Original, yes.
Okay. And what happened with that case?
I did time served 113 days.
And that was in the county jail?
County jail, yes, sir.
Okay. So was it pled down to a misdemeanor?
Yes.
Okay.
1244.
Okay. And so that was in 2017.
Correct.
Okay, then in 2018, you had a couple of cases too, didn't you?
One case.
Okay, well, but you had one case in Kaufman County and then one case in Van Zant County. Is
Right.
that correct?
Van Zant was not in 2018, but 2023.
Okay, so in 2018, you had a Kaufman County case. What was that?
Possession of a controlled substance less than a gram.
Okay, so that was a state jail offense also, is
Yes,
that
sir.
correct? And what happened with that case?
Time served,
Oh.
93 days.
Okay, so that was reduced to a misdemeanor also, is that
Yes, sir.
correct? Okay, and then, I'm sorry, in 2020, you had a case in Van Zant County.
Correct.
And what was that?
That was criminal mischief,
And was that a misdemeanor or a felony case?
misdemeanor.
Okay, what happened in that case?
I did my time served,
And was that 32 days?
32 days.
Okay.
County time.
Okay, aside from those three, have you had any other times that you've had criminal cases?
No, sir.
Okay. Have you ever had a time that you have been able to make it out on bond and failed to appear for court?
No, sir.
So you appeared when you were supposed to in all
Yes.
three of those cases?
Yes, sir.
Okay. Are you telling this court that that if he were to grant you a PR bond or lower your bond here today in some way and you were able to bond out, that you would come back to court?
Yes, sir.
Okay, now you understand that this case involves drugs. You understand that?
Correct.
Okay, you know, so that you understand that concerns the court.
Right.
Okay, and you understand you have a couple of cases in your past that involve drugs also. So you understand that's going to concern the court too. If the judge was going to lower your bond, but make a condition that you do random UAs or report periodically to the probation department, would you be willing to do that?
Yes.
Okay. And Maybank is what, 25, 30 minutes from here?
It's the outskirts of Maybank, so like 15, 20 minutes.
Okay. So you'd be able to get back here if you were ordered to come back and
Yes,
either
sir.
come to court or come to report to a bondsman?
Of course.
Okay. I'll pass witness.
Thank you,
Mr.
Judge. Just
Strong.
maybe one question. What is your means of transportation to get into court?
That would be.
And your mother will drive you here?
Yes.
Okay, so there's not gonna be a problem
No,
obtaining transportation?
no.
Nothing further.
How old is she?
28.
You ain't gonna look 28 for long. You've seen people that do meth for a long time. You see what they look like. Her bond is actually set reasonably. I mean, even first time offenders bond is set $8,500 typically from the JPs on a PCS. However, the court will grant the writ, reduces bond to $3,500 surety bond. As a condition, no alcohol, no drugs that are not prescribed, no marijuana, and no illegal drugs. I will grant a PR bond if she could find a substance abuse facility that she could check into, because she's 28 years old and has been doing this probably for longer than she's been caught. And she's at the age now that she's either going to go downhill or go uphill, really prove herself. So I would grant her a PR bond with the condition she check into some inpatient treatment.
Your Honor, she has told me she's been looking into Nexus in Dallas for that very
I'm
purpose.
familiar with it.
So I don't know if that answers your question or not.
Yeah, if she's, well, I've already ordered it, but I appreciate it. But no, I mean, it's, and it's more important to me that you stay clean. And a lot of times I can keep you clean by keeping you in jail. And then also if I keep you clean, things like burglaries and sexual assaults and murders and robberies and burglaries and theft of metal and credit card abuse, those cases go way down when people are clean. So $3,500 surety or $8,500 PR with the condition that she check into an inpatient rehabilitation center.
Thank you.
Okay. Thank you, Your Honor.
Yes, sir.
I don't know how you write that on that order.
Well, I'm just submitting the order for the surety bond.
Okay.
But if y'all get that arranged, just get me an order and I'll sign it.
Understood.
I won't go back on my word. You have to remind me.
Next, I think we have Lamonte Rodriguez.
All right, these are cause numbers CR 21-0065 and 0066-173. Both styled the state of Texas versus Lamonte Rodriguez, and both set today on a motion to reduce bond. Is the defendant ready?
We're ready, Your Honor.
And the state?
We're ready, Your Honor.
And are we going to hear testimony from Mr. Rodriguez for the limited purposes of bail?
We are, Your Honor.
Mr. Rodriguez, if you could raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand.
Okay. And your name is Lamonte Dequan Rodriguez, is that correct?
Yes, sir.
And I'm pronouncing that correctly?
That's Lamonte.
Lamonte. Okay. And you are the same person who has now been indicted on 2 charges of aggravated assault with a deadly weapon. Is that correct?
Yes, sir.
Okay. And each of those bonds, the bond in each of those cases is set at $500,000. Is that correct?
Yes, sir.
Okay. So that's a total of $1 million in bond.
Yes, sir.
Okay. And now you were here in front of this court, I believe it was last week, and were arraigned on those charges. Is that right?
Yes, sir.
And how long have you been in the Henderson County Jail?
5 months.
About 5 months?
Yes, sir.
Okay. And have you been able to come up with, or have you talked to any bondsmen to find out how much it would even cost to make $1 million in bond?
I haven't, but my family has.
Okay. And is it your understanding that your family does not have enough money to bond you out on that?
Yes, sir.
Okay. Now, when you talk about your family, who is that? Or who are they? How are they related to you?
My aunt, my wife, my uncle.
Okay. And now, your aunt is here in the courtroom with us today. Is that correct?
Yes, sir.
And now, your uncle and your aunt, they're not married. They're different.
Yes, sir.
Different sets of people, right?
Yes,
Okay.
sir.
And then now you call her your wife. Are y'all actually married?
Yes, sir.
Okay. She really kind of like a fiance. Okay. And where does she live?
She stays in Kent, Texas.
Okay. And so are they all working together to try to help you with bond?
Yes, sir.
Okay. But they're unable to make what it is currently. Is that right?
Yes, sir.
Okay. And now, do you have any, do you own any possessions such as a house, car, big screen TV, computer, anything like that?
The house I own, me and my sister own it together. My mom passed away and left it to me and my sister.
So it was inherited by you and your sister. So you can't sell your house.
Yes.
Okay. And do you have any other, do you own any other property?
No, sir.
Okay. What about money, either cash or bank accounts,
No, sir.
savings accounts,
No, sir.
gold bars, anything like that?
No, sir.
Okay. Have you talked to your family about maybe how much money you think they may be able to come up with?
No, sir, I haven't.
Okay. And, but you know they can't come up with what it is now. Is that right?
Yes, sir.
Okay. Now you understand that the purpose of bond is one, to make sure you come back to court and handle these cases.
Yes, sir.
And then the other thing is to ensure the safety of the public, right?
Yes, sir.
Okay. And you understand the charges in this case are somewhat serious charges.
Yes, sir.
Okay. And now, if the judge was to reduce your bond to something you could make, where would you live?
My aunt,
Okay. Where does she live?
she lives here
Here in Athens? If you weren't able to live with her, where would you live?
with my fiance.
In Kemp? Okay. Would you be coming back to court to handle this?
Yes, sir.
Okay. And we already think we have a date on this case. Is that on May 12th? You have to come back. Would you come back on May 12th at 1:30?
Yes, sir.
Okay. And Are you, if you're released, are you going to possess any firearms or bow and arrows, Bowie knives, switchblades, anything like that?
No, sir.
Okay. Are you going to stay away from these people who are listed as the victims in this case?
Yes, sir.
Okay, you're going to stay away from wherever this happened?
Yes, sir.
Okay. You understand the judge could put conditions on your bond that you have to report maybe once a month or more, sometimes more.
Yes, sir.
That you have to do random drug testing, other things, put other conditions on it too. You understand that?
Yes, sir.
Okay, and the law allows him to put any reasonable recommendations, any reasonable conditions on that bond. You understand that?
Yes, sir.
And so if this judge was willing to lower your bond, but put some kind of conditions on it, would you follow whatever conditions he put on it?
Yes, sir.
Okay. I'll pass the witness.
I have no questions, Your Honor.
Any other witnesses?
Your Honor, I would call Angela Sessions. Say that one.
Angela Sessions?
She has not been sworn, Your Honor.
If you can raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. Mr. Hunt.
Ms. Sessions, how are you related to Mr. Rodriguez?
He's my great nephew. His brother was
Okay, and go ahead and step up here a little bit, because with that mask on, it's kind of hard for them to hear, and speak as loud as you can, okay? Say, and how are you related to him?
He's my great nephew. His mother was my niece.
And have you talked to Mr. Rodriguez about his bond? And are you able to help him with his bond as it is now?
Yes, I would do what I have to do.
Okay, but you understand it's set at $1 million.
Yes.
Do you think you could make $1 million bond at this time?
No.
Okay. If the judge was to lower the bond to something that that you could help him with, you would help him? Is that what you're saying?
Yes.
Okay. How much do you think that you and I guess your family working together, how much do you think y'all would be able to come up with?
What? Maybe four.
Four or 5,000 maybe?
Yeah.
Okay. And okay. And would y'all, if the judge did lower the bond and y'all were able to help Mr. Rodriguez get out, would you keep an eye on him and make sure he does what he's supposed to do?
You know, I do it anyway.
Okay.
It just doesn't work sometimes.
Well,
I mean, I'm there.
okay. I'll pass witness, Your Honor.
Mr. Cox?
No questions, Judge.
Anything else?
That's all, Your Honor.
Mr. Cox?
Your Honor, the state has no witnesses. However, if the court's familiar with the ongoing feud in North Athens, this is a part of that ongoing episode. In fact, Mr. Russell, who was in court earlier today, represented by Mr. Head, who stated he needed to sit down because he had experienced a gunshot wound. He's one of the alleged victims in this offense. Additionally, in 2013, Mr. Rodriguez, out of this court, was sentenced to 5 years for a robbery.
Okay. Anything else? I think I signed the arrest warrant, the search warrant, or did I not? Anything else?
No, Your Honor.
All right, well then, based upon the safety of the defendant and the safety of the community, the court denies the motion to reduce the bond. Bond will remain at $500,000 on each case.
Thank you, Your Honor.
Sir. think we pushed on. Good. On this, on the bond violation report on Mr. Rockmore, I've had him sitting over there a while. Are we doing anything? Are we gonna have a hearing on that, or what do I need to do on that? I keep looking over at you and I'm thinking, are you waiting on me? I thought you are.
We were waiting on Mr. Rockmore's case to be called.
Okay,
And I do have one more, Your Honor. I
Right.
apologize.
sorry, I saw you walk. Yeah, let me handle, finish Mr. Hunt.
Clayton Robinson, Your Honor. I believe he's at the bottom of page 5.
Clayton Lamar Robinson.
Your Honor, I think we may have reached an agreement on a bond
On
in this
bond?
case.
No, let me call it. Well, I did call it, didn't I? No, I didn't. CV 21-0118-173 ex parte Clayton Lamar Robinson set today for a writ of habeas corpus seeking bond reduction. And y'all have an agreement?
Yes, Your Honor, we've agreed to a $5,000 bond in this case.
And is there a protective order in place?
There is, Your Honor.
Okay. All right, well, then the court's going to approve the agreement. Conditions of bond are, and I'll just write them right here. Even though he has a protective order, I'm gonna make bond conditions, no contact with victim. No contact with victims' place of employment or home. All right, you understand that? I'm saying it in open court. No contact with the victim. There's already a protective order in. The state has agreed to this. And no contact with the victim's place of employment or home.
Yes, Your Honor.
All right. Yes, sir. All right, do we want to handle Mr. Rockmore now? I guess what I needed to know, are we having a hearing? Is the state not, I mean, normally when I get this, the state's asserting it and they want to find his bond insufficient. Come on up,
Yes,
Mr.
Your Honor,
Rockmore.
we would like to have a short hearing.
Okay. I just back on the record in cause number CR 19-0140-173, the state of Texas versus Tedrick Deshaun Rockmore. A bond violation report has been presented to the court, and I guess we need to have a bond hearing. Is that correct? Bond violation hearing?
Correct, Judge.
Yes,
All right, is the state ready?
Yes, Your Honor.
And on behalf of Mr. Rockmore?
ready, Your Honor.
All right, and state?
State, I'm gonna call, I'm sorry, Judge, I'm gonna call Miss Brenda Skinner.
And does anyone mind if I waive the oath since she is an officer of the court?
That's fine, Judge.
Okay, go ahead.
Miss Skinner, do you know Mr. Rockmore?
Yes, I did.
And how do you know him?
He was placed on bond supervision.
And who actually ordered the bond supervision?
Judge Moore.
And what were the bond supervision's conditions?
The ones that he violated was that he was to report to our department every Tuesday and every Friday and pay $40 bond supervision fee to our department. And then the defendant will obtain a job at Red Dot within 1 week of release and furnish our department a reason why he was not employed.
Okay, and how did he not report every Tuesday and every Friday?
Well, out of his reporting, he did not report on October 30th, November 10th, or January the 29th. Sorry, October 30th of 2020, November 10th of 2020, and January 29th of 2021.
And when he didn't report, did he call you and let you know he wasn't coming? Did he give any excuses why he didn't report? He just didn't show up.
He would usually call.
Did he also fail to pay any bond supervision fees?
Yes, he was ordered to pay $40 per month bond supervision fee to our department, and he has failed to do that in October and November of 2020, but he has a delinquent amount of $81 at this time.
And you said he failed to obtain a job at Red Dot within 1 week of his release, is that correct?
That's correct. He did tell me that he was not eligible for rehire whenever he was released from custody at Red Dot. And then he did tell me that he was employed with Raymond Neal, which I did verify that for a while in September of 2020. And then the work slowed down in December of 2020, and a defendant got a job at Athens Park Home on January the 26th of 2021, but then lost the job on February 2nd of 2021, and has been unemployed as far as I know since then.
So he was employed in September
Yes,
and December
yes,
and January, is that correct?
and yes. 4 days in January.
So are you saying that he didn't work as needed?
Correct.
Has he committed any other offenses that you need to let me know about?
Because of a phone call, I did drug test him, and on February the 23rd, he admitted that he had smoked methamphetamines on February the 21st of 2021. I drug tested him on February the 2nd, and he tested positive for methamphetamines, amphetamines, and THC, which he admitted that he had smoked marijuana on February the 1st, but denied the methamphetamine, so it was sent to the lab for confirmation, and the lab confirmed it positive for amphetamines and methamphetamines. Then also on January the 19th, he tested positive for methamphetamines, amphetamines, and THC, and he admitted that he had used marijuana on January the 19th, but denied methamphetamines and amphetamines. I sent it to the lab, and it was confirmed positive for amphetamines and methamphetamines.
What is your recommendation at this time?
That his bond be found insufficient.
Mr. Stevens.
Thank you, Your Honor. Part of Mr. Rockmore's conditions not only was to get a job at Red Dot, but he was unable to seek employment elsewhere. Is that correct?
That's correct.
And he did that, correct?
He did.
Okay. And did he discuss with you the difficult time he has in locating a job because of the, pending aggravated robbery charges against him?
He did voice that.
Okay. But he has appeared to be looking for a job from what you can understand. Is that correct?
Well, I have instructed him to bring me at least 2 applications that he has completed and turned in every Friday, and he has done that on 2 occasions.
Okay. And I think that he missed about 3 different report dates, if I'm not mistaken. Other than those 3 times, has he been pretty diligent in coming in twice a week?
That's correct. He has.
Okay. And the times that he did miss, I think you testified that he did call in.
He did call to talk to me about him.
Okay. I'll pass witness.
Anything else?
No, Your Honor.
Any witnesses or any other witnesses?
No, Your Honor, state rest.
Mr. Stevens?
Call my client.
Okay. Ms. Rockmore, if you can raise your right hand, this is for the limited purposes of this bond violation hearing. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You know your hand. Mr. Stevens.
Thank you, Judge. Please state his name for the record. Mr. Rockmore, you've heard the testimony here today, obviously, and do you recall when Judge Moore put you on these bond conditions?
Yes, sir.
Okay, and one of the requirements was of you to go back to work at Red Dot, is that right? However, tell the judge what happened when you tried to go back to Red Dot.
They had filled my position. And I had to find another job.
You had been in jail for what, 10 months or something? Okay. But when you told the judge that you had a job at Red Dot, you said that in good faith. You thought you had it, right? Okay. Now, you did go to work somewhere else. Where did you go to work?
Right, we did.
Okay.
Multi-purpose, like mowing, construction.
Okay. And how long did you work for him? Okay. What have you done the last couple of months for employment? Looking for a job? Okay, you got to speak up so that she can hear, okay?
Looking for a job.
Okay, and have you been taking the reports by the probation department, like the places you go to look? Have you been doing that to show them?
Yes, ma'am. But yes, sir, I had just started bringing those applications in.
Mhm.
So it really, I missed one Friday of bringing the application in.
Okay. What, on the 3 particular times, do you recall that you didn't show up? Were you working or you recall what
I
happened?
remember 2 of them. One of them was when I went to the doctor. And then the second one was, I didn't have a face mask when I came in. That's my fault.
Well, they send you back out or something different. Okay,
Yes, sir.
let's talk about the drug use. Okay, that's a big deal.
Yes, sir.
Right.
Yes, sir. Yes, sir.
Okay,
Yes, sir.
and I think you told me that you have not smoked meth.
Yes, sir.
Is that
Yes,
correct?
yes, sir.
Well, explain to the court how come it's in your system.
I was.
Well, she's got to hear what you say. Why, if you didn't smoke, why is it in your system?
I did smoke.
What do you say?
I did smoke.
Okay, I misunderstood you. I thought you told me that you had not smoked.
Mm.
When we talked a while ago, I thought you told me you had not smoked.
You talked a while ago, I had told you, you asked me would I be clean? I said, no, sir, I wouldn't.
Okay.
And I told you I was working on it. I don't do it. Like, I'm not. I was going through stuff. Stress.
I can't.
Okay. Yeah,
Can you take it down so I can make that one?
I was just going through. Like, the address I had to stay at my brother's house, the court order
Yes.
address. Like it's a bunch of kids, my niece and nephew there. Yeah, I really don't have an excuse for it. Like I shouldn't have been doing it.
Okay, he said, yeah, an excuse.
I shouldn't have been doing it. I shouldn't have been using it. I shouldn't have been.
Okay. Are you asking the judge to not revoke your bond and hold it insufficient?
Yes, sir.
Are you going to tell this court that you'll not smoke any substances, whether it's marijuana,
Yes, sir.
whether it's a meth or anything at all?
Yes, sir.
Okay. Make that promise to the judge.
Yes, sir. I promise.
And how about your work? I mean, you worked there for a while, but now you've been out of work. You got to, listen, wait, let me finish asking. Okay. What are you going to do if he doesn't lock you up? What are you going to do to try to find employment? As soon as we leave, what are you going to do?
Go find something. I'm gonna find anything, wherever it is. I'm gonna have to go find it.
Have you gone to the workforce?
Yes, sir.
Okay, you have done that?
In the work code. I
Okay.
went to both of them.
Okay. I pass witness, Judge.
Okay, correct me if I'm wrong, but did you just say that you were staying at your brother's
I'm
house?
saying.
Okay, with lots of kids, and that's the reason you're smoking meth?
No, that ain't the reason. It's just, I was just stressed out. This course, like, I didn't do nothing to get in trouble. Like, I was just at the wrong place at the wrong time. I was just, like, it ain't no reason for it. I just did it.
So are you smoking meth around the children?
No. No,
Okay.
ma'am, no, ma'am.
But you did sign both of these acknowledging that you did smoke the meth,
Yes,
correct?
ma'am.
Okay.
She asked me and I told her, like, they asked me about this case and I told them, like, I told them the truth, like, yeah.
And you did test positive for meth, amphetamines, THC,
Yes, ma'am.
all while on bond conditions, correct? And even though that wasn't one of your exact bond conditions, you knew that you shouldn't have been doing it. Do you think that might have had something to do with you not being able to find work?
No, ma'am.
You know? Okay. And right now you are delinquent on your reporting fees, is that correct?
Yes, ma'am, $81.
And why are you delinquent on those? Who bought the drugs?
All right, well, now we're getting into it's limited purposes bail.
It was really a friend that I wasn't even supposed to be around, a person that I wasn't even supposed to be around.
Okay, let's move on to the next
Hey, that's
question.
cool.
It's limited purposes bail.
I'm saying she asked me.
No, you're fine. I'm stopping her and you. So y'all, for your safety.
Yes, sir.
No other questions, Judge.
Okay,
No
anything
other
else?
witnesses.
Is there a probable cause affidavit that I can review? Because this will transfer from Judge Moore's. I mean, I know what the indictment says. I'd like to look at. I mean, I'll just be honest with you, a $30,000 bond on an aggravated robbery with a firearm is extremely low to me, but I didn't set it. So I'm wondering if there's some kind of.
I don't do it like that. I don't do it.
But that's not my, it's not my right. Well, it could have been my grand jury.
I'm just around it. I'm just wrong. Mistake I made.
If I may see the probable cause. Unless it's the PCS, you have it for the ag robbery.
Oh, I'm sorry.
It may be attached to this. Should be at the back of the offense report on the aggravated robbery. I'll hand that back to her so I don't have to slide it through the glass. Can you give it to Kevin? I'm just giving that one back to you. That was PCS.
Judge, you know, this was one of my files. I just want to say you're.
No, I told, trust me, when they are my files, I still can't find anything in them. I can never find anything in the clerk's file. It's because we tie them down backwards.
Yes, they're backwards.
Amazing.
Judge, I'm printing a copy right now.
You printed here? Y'all have a printer over there? No, I think it's a great idea. I've only been trying to get one in there for 12 years. So the there are 3 individuals. Do we know what the bond on the other 3 individuals were? It was a Hannah Wolf and a Jasmine Blackfeet.
Blackfeet's already pled, Judge.
And what? I was
She
trying to.
pled open to Judge Moore, and then she fled. She's gone. She's in the wind.
I knew I remembered that. name.
That's why you remember, Judge.
Hannah Wolf.
You appeared in court last week. 25,000 PR bond on this wall.
I'm saying maybe there's something I don't know about, hearings that were had that I don't know about. Because reading this probable cause affidavit, it doesn't appear that Mr. Brockmore, the one with a gun, it was a female.
He was not, Your Honor. He didn't have the gun and he wasn't driving.
All right, but he was with them. And so I'm sure I'm sure that if it did go to trial, I would hear the term law of parties.
I'm sure, Judge.
And Mr. Rockmore,
Yes, sir.
I'm just gonna tell you that some of my favorite restaurants can't even open because I think Tony's is one of them over there by you, Bill. It's because they don't have enough staff. The government's just printing money and giving them to everybody. I didn't get any. I don't know if you did.
I didn't either.
Well, you should have.
I didn't.
You didn't apply then.
I did. No, I didn't.
Then,
Yes, sir.
and so nobody wants to work because, and so when nobody wants to work, there's no place to go eat and there's no place to, the business owners can't run their businesses. So it's your lucky day. I'm just going to tell you that because when I see aggravated robbery with a firearm and I see a $30,000 bond, to me, there's something going on, which is why I wanted to dig further.
Yes, sir.
I don't know what your part was, but you weren't alleged to have a gun. If you did, you'd be going with these gentlemen.
Yes, sir.
I will tell you this, though. Everybody gets their one free shot in my court, and you haven't been in here yet. If you come in here again, you don't know how lucky your day is. And I'm glad that I took the time to give you a fair hearing and to look into this.
Yes, sir.
If I'm going to test you the next time you come in here in April, is that when we reset it?
We haven't reset it.
Oh, I'm resetting it for April 29th at 1:30. I'm going to drug test you again.
Yes, sir.
If you test positive,
Yes, sir.
I can't promise you things. I can't pre-rule, but you may go out that door and not that one
Yes, sir.
with a way bigger bond than that $30,000 bond.
Yes, sir.
And I'm also going to make it a condition in your bond that you're not to be around if it's not already Jasmine Blackfeet or Hannah Wolf.
Yeah.
And then well, it's already in there.
Everything, yeah.
So
Thank you.
find a job.
Yes, sir.
Your self-confidence will go up and everything. I guarantee you somebody out there will hire you, but you got to look, you got to want it.
Yes, sir. Thank you.
Stay off the meth.
Yes, sir.
Yeah, Beanerborough kind of thing, batons.
All right. You're good to go. Thank you. Thank you, McKee.
Don't let me down. Don't let me down. Yes.
And also, Judge, Mr. Bone took his drug test.
Yeah, let me hand it while y'all are doing that. Mr. Bone, come on up.
So, Judge, what was it?
Awesome.
It's back on the record in cause number CR 21-0017-173, state of Texas versus Kenneth Bone. And Mr. Bone was ordered to take a drug test and he has tested positive for methamphetamine. He admitted to smoking it allegedly on March the 23rd. Mr. Bone, again, of course, I'm familiar with you. But anyway, it's your first time in front of me in this court, right? This is the first time in here?
It is, Your Honor.
Right, and you get your free shot with me the first time, because I believe in being fair and giving people notice. Your own conditions of bond, no drinking alcohol, no illegal drugs, no drugs not prescribed, and no marijuana, no matter what state or state of mind you're in. And so, once you receive those conditions, you can be free to go. And I'll tell you, like I told Mr. Rockmore, because I treated him the same way I treat everybody else. You come in here the next time, I'm gonna test you when you do. And I can't promise you'll go out that door. If you test positive, you may go out that one. You understand? See you in April.
Speaking of UAs, Ms. Thomas, Mr. Skelton's client, probation's informed me that she's not only having a hard time providing samples, she's also throwing up all over their office right now.
All right, let's wheel her right to the door. Mr. Bone, take care. We'll see you in April.
He's already gotten it.
Oh, okay.
Tina Thomas.
Tina Thomas.
If she's throwing up, I don't want her in here. I prefer her at the door. She have a mask on?
Yes, John.
I mean, I'm immune, but other people may not be.
John, I'd like, this court, please, I'd just like to inform the court of something.
I can't hear you.
When the court asked if we've been plea bargaining, well, we had been plea bargaining, but we hadn't. And I think I said, no, that's not true. I'd been given a plea bargain offer
on Friday, this past Friday, and I just really hadn't had a chance to talk with my client about it. But she showed up this morning, and I guess I just, the way she was, I got confabulated, I guess.
That's all right.
So I didn't intentionally.
Here's what I'm gonna do. I'm just gonna reset her to April, put conditions of bond on.
She's back in probation now. She's trying to do the test.
Right. So here's what I'm gonna do. I'm gonna, I'll recall it. I don't want her in here. She's sick. I don't think we have. Back on the record, cause number CR 19-0378-173, the state of Texas versus Dina Thomas. For the record, Ms. Thomas is not in the courtroom because the court has been informed that she's throwing up all over probation's room. Normally, she would be in here based upon the emergency orders issued from Supreme Court. We're on number 36 now. The governor's state of emergency and the Chinese coronavirus, which has caused death and devastation worldwide. The court is not going to bring her in. It's going to reset her case to April the 29th at 1:30. I'm also placing conditions of bond on her. There'll be no alcohol, no drugs not prescribed, no illegal drugs, and no marijuana. And so we're going to provide her those in writing. And again, I am not bringing her back in the court.
All right. Thank you, Your Honor.
Until April, basically.
Yes, Your Honor. Mr. Skelton mentioned the state's plea offer. For the record, Thomas has an unindicted PCS as well. My offer is time served on a 1244B on the indicted cause number, the one we're here for today. And I would ask the court to consider and dismiss the unindicted PCS case. So that's the state's offer.
Yes, that's correct, John.
Is that open till August? I mean, till April?
Until April, yes,
Okay.
sir.
All right. So if you can communicate that with her, Mr.
I
Scott.
will. Thank you, Your Honor.
Hang on, Hank, let me get you these bond conditions.
Okay.
He's been working hard. I saw him back in the jury room. Sorry. All right, that should take care of you, Mr. Skelton. Appreciate it. Good to see you.
Thank you. Thank you, Your Honor. Good seeing you.
And Mr. Harrington. Is it Leila or Leela or
Layla.
Layla?
Yes.
All righty, these are cause numbers CR 19-0678 and 0679-173. Both styled state of Texas versus Layla Desiree Acock, and both set for trial docket status. However, a plea has been presented on the 0679 case. Is the state ready?
State's ready.
And on behalf of Ms. Acock,
No, we're present, right?
ma'am, is your name Layla Desiree Acock?
Yes, sir.
And are you the same person that was originally indicted by Henderson County grand jury in this case for the state jail felony offense of abandoning or endangering a child by criminal negligence?
Yes, sir.
If I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Ms. Acock, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen, you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Ms. Acock, have you ever been treated for any mental health or emotional issues? And what would those be? Step forward a little bit. I can't hear you.
Clinical depression and a personality disorder.
Okay, are you on medication for that?
No, no.
Are you in counseling?
Yes,
Okay, and are you attending that counseling as you are directed?
yes, weekly.
Okay, and but do you understand what's going on in here?
Yes.
And Mr. Harrington, you believe your client is competent?
I believe she is, Judge.
All right, well, Ms. Aycock, even though you've told me you've had these diagnoses, basically, the law presumes you client, and the answers to my questions, your demeanors, and the statement of your attorney, the court finds no reason not to, and so the court finds you are competent. Ms. Aycock, I know that you've already been arraigned in Judge Moore's court on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, thank you.
But do you understand the charge?
Yes, I do.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, I do.
And the plea bargain?
Your Honor, the state recommends 2 years confinement probated for 5 years to include the time credit of 70 days as of today, $2,000 fine, $800 in attorney's fees, $299 court costs, Crime Stoppers fee, drug testing, GED in 24 months, 300 hours of community service, a substance abuse evaluation, and to follow any CPS requirements that exist. We're also asking the court to consider 2 bail jumping, unindicted bail jumpings from July 13th of 2020.
Is that your understanding of the plea bargain, Ms. Aycock?
Yes, Your Honor. We've also filed a motion to dismiss in the 0678 case.
Because it's not being considered.
That's correct. We're only asking the court to consider the unindicted bail jumping.
Okay.
Dismiss the
Understood.
That's my opinion.
All right. Well, Ms. Aycock, a few minutes ago, I asked if you could read and write the English language. You told me you could. We'll go over 2 of the documents that you went over with Mr. Harrington. First is the agreed plea recommendation. Did you read and go over that document, both front and back, with Mr. Harrington?
Yes, I did.
And did you sign the front and back?
Yes.
Do you have any questions about it?
No.
The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those pages with Mr. Harrington?
Yes, I did.
And did you sign it?
Yes.
Do you have any questions about it?
No.
Do you have any questions about any of the documents you read and went over with Mr. Harrington?
No, I don't.
Well, if you read and went over these with Mr. Harrington, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No.
Do you want to enter into this plea bargain?
Yes.
Then I'll ask you, ma'am, how do you plead to that state jail felony offense of abandoning or endangering a child by criminal negligence as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I hear the evidence.
Your Honor, the state offers Exhibit 1 a copy of the offense report and Exhibit 2 a copy of the initial inventory.
Objections.
Admitted. Anything else from the state?
Take rest and close, Your Honor.
No, we rest and close.
All right, then, Ms. Aycock, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense as alleged in the indictment. The court will follow the plea bargain, considers the unindicted cases annotated on the plea recommendation sheet, and sentences you to 2 years in a state jail felony facility. However, the court will probate that, places you on community supervision for 5 years. You do have 70 days credit as to any sentence you may eventually have to serve in order to pay your fine, attorney's fees, and court costs, and to abide by all the regular and special terms and conditions of community supervision. And Ms. Aycock, have you ever been on probation before?
No.
All right. Well, there's a lot of things you have to do and a few things you can't do on probation. Do you understand that?
Yes, I do.
Do you know what can happen to you if you violate any term or condition of this probation?
Yes.
What can happen?
I can be confined in jail.
All right, here's what can happen. A motion could be filed, a warrant would be issued for your arrest, you'd be brought back, you'd be placed in jail with no bond, brought back before the court. If the court found it were true that you violated even one term or condition, especially these CPS requirements, the court could revoke your probation, and sentence you to 2 years in state jail. Do you understand that?
Yes.
Do you know how state jail time is served?
Day for day.
Day for day, generally speaking, that's correct.
Yes.
And so a few more things I need to go over with you, Ms. Acock. Now that you have been found guilty of this offense, this felony, you're now under Texas law ineligible to possess a firearm or ammunition. Have any questions about that? Refer to the document in your packet or consult with an attorney. And does she have a CPS case right now?
I'm not sure if it's closed.
I believe it's closed out, Your Honor.
Um,
CPS, I believe, it closed out.
The children have been returned, if there were children?
Would not.
They're with the
With
father,
father.
and I have a Rule 11 has been established in the court order.
Also, Judge, I believe she's a resident of Smith County. She may be requesting transfer.
It's okay with probation. It's okay with me. All right, ma'am, you need to meet with probation. Good luck to you. I don't want to see you back in here. Oh, I forgot to send her to you, Ronnie. Sorry. I knew I was getting something. Yes, sir. You got a couple more, don't you?
Yes, sir. Granger on page 5. We also have a please present the court.
Moving some cases today. Thank you, ma'am. Just a minute. All right, this is cause number CR 19-0913-173, State of Texas versus David Paul Granger. Set today for trial docket status. However, a plea has been presented. He is the state ready. And on behalf of Mr. Granger.
No, we're present ready.
All right, sir, is your name David Paul Granger?
Yes.
And are you the same person that was originally indicted by Henderson County Grand Jury for the second-degree felony offense of aggravated assault with a deadly weapon?
Yes.
If I get you to raise your right hand, sir. Your other right. There you go. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
You can lower your hand. Mr. Granger, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen, you enter into this plea bargain with the state, it could cause negative immigration consequences. Do you understand that? And I need you to answer a little louder. It's my hard time hearing. And Mr. Granger, have you ever been treated for any mental health or emotional issues?
Yes, sir.
And what would those be?
PTSD, bipolar, schizophrenia, manic depression, anger, they said implosion disorder.
Okay, so a bunch of them.
Yeah, I guess you can.
And are you on any medication for that?
Yes.
And are you taking that medication as prescribed?
Yes.
Do you understand what's going on in here today?
Yes.
And Mr. Harrington, how long have you represented Mr. Granger?
Your Honor, I believe since 2019, I believe.
Quite some time.
Yes, sir. And there's been some examinations in the past. I do believe my experience for the last 2 years with he's confident and competent.
Okay. Well, Mr. Granger, even though you've told me you've had these diagnoses, but you've told me you've taken medication, the law presumes you competent based upon your appearance today, as well as your answers to my questions and the statements from your attorney, the court finds you are competent. Now, Mr. Granger, I know that we've already arraigned you on this case, or they did over in Judge Moore's court. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
If you like to see.
No, it's not whether he does, it's whether you want him to.
Wait.
All right. And the reason I ask that is to make sure you understand what you're charged with.
Okay.
All right. But do you understand what you're charged with? All right. Well, that charge as originally indicted is a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years nor more than 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment? You got to answer out loud.
Yes, sir.
All right, she has to take it down. She can't take down a hit.
I'm sorry.
You're all right. Are you nervous?
Yeah.
Well, I'm not, so you don't have to be.
Very nervous.
All right, you're all right. However, it's my understanding that the state is willing to recommend that the court convict you and punish you as a Class A misdemeanor on the lesser included offense of that which is charged in assault. A Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine not to exceed $4,000. You understand that range of punishment?
Yes, sir.
And the plea bargain?
26 days confinement in Henderson County Jail, credit for 26 days served, plus attorney's fees and court costs.
And abandoning an enhancement paragraph,
Yes, sir.
which wouldn't apply to a Class A anyway. All right, is that your understanding of the plea bargain, Mr. Granger?
Yes, sir.
Is that your understanding, Mr. Harrington?
Yes, sir.
Mr. Granger, you told me you could read and write the English language a few minutes ago. I'm going to go over 2 documents with you. First is the agreed plea recommendation. Did you read and go over both front and back of that document with Mr. Harrington?
Yes, sir. This morning we did.
Did you sign the front and the back?
Yes, sir.
Second document I want to show you. Well, let me ask you, do you have any questions about that one?
No.
The second document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages with Mr. Harrington? Is that your signature there on the second?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you went over with Mr. Harrington?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes. The only question I had was, he showed me
You
the
can step
fine.
up closer. I don't
He
buy.
He showed me the amount on the fine.
Uh-huh.
And I live on SSI benefits, me and my wife, and I got a 4-month-old, so I was kind of like, I don't know.
It's not up to me. I don't make the deals. All I do is either approve them or not approve them.
Yes. Just like we talked about outside, you have 6 months to pay it. You have 60 days instead of pay it off in 6 months.
Are you working?
Am I working?
Yes, sir.
No, sir, I'm on SSI.
Can you work on SSI?
No,
Normally you can work a certain amount of hours still at
Yeah.
they won't let me work longer than 2 hours a day.
And work 2 hours a day. All right, get where I was.
Think about to ask for this.
I didn't take his plea yet. Did I?
Said guilty.
Let me ask you again. Sir, how do you plead to the lesser included offense of that which is charged in the indictment, that Class A misdemeanor assault? Guilty or not guilty?
Guilty, sir.
And are you pleading guilty because you are guilty for no other reason? Yeah, I hadn't taken this plea. I hear the evidence.
Judge, states 1 in offense report, and states 2 is Michael Morgan's compliance. No objection.
Admitted.
Rest
And
to close.
is the complaining witness on board?
Your Honor, the prior administration sent a letter to the complaining witness who did not respond. I tried to call that person today. Numbers no longer work.
Okay, well, then the court finds that the complaining witness cannot be contacted and good faith has been exercised to contact the complaining witness. Anything else?
No, Judge, rest to close.
Mr. Harrington?
Rest to close.
All right, Mr. Granger, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included Class A assault. And the court will follow the plea bargain, sentences you to 26 days in the Henderson County Jail with credit for 26 days and orders you to pay your attorney's fees and court costs. Mr. Granger, did you have an opportunity to review the judgment with Mr. Harrington?
Yes.
And is your name, the charge, and the time credit correct?
I'm trying to see. Yes, sir.
All right. All right, sir. You need to see Mr. Halbert to your right. Good luck to you.
That's it, sir.
That's it.
Thank you. God bless you.
You're the Rangers released Rugi.
They released Rugi. What about his horse? Did they take it back?
That's a good question. I don't know about the horse.
You know, the only reason I really loved Rugi is I love it when he hit those home runs
And the punch.
and the punch. And I loved his gangster way he wore the uniform all unbuttoned and stuff.
Yeah, down to his belly button with the chains hanging down.
Yeah, love it.
He made a lot of money off that punch.
Oh, yeah. Andre Johnson?
Yes, sir, he's present.
And what are we doing there? Is it a plea?
No.
Okay. All right, Mr. Johnson, you had the unlucky fortune of being the last one and the nicest dressed guy in the courtroom. I noticed when you walked in. I wish everybody dressed like that for court. CR 19-0794-173, the state of Texas versus Andre Johnson Jr. set for trial docket status. Where are we at?
Judge, we're gonna ask the court to reset this for April 29th. Mr. Harrington came by my office a couple weeks ago, provided me with some information I needed to look into. I haven't had a chance to do that yet, but I plan on doing that in the future.
Okay. All right, Mr. Johnson, then court's going to reset your case to April the 29th at 1:30. Stay in touch with your bondsman, stay in touch with Mr. Harrington, we'll see you in April. Can't wait to see what outfit you wear on that day.
Appreciate it, man. Have a good one.
You too.